morning, Mr. Jacobson.
Good morning, Chief Justice. If it were not for Massachusetts General Laws 265, Section 43, the stalking statute, I would not be making this argument. That is to say, if it were merely based on the principles of the concept of stalking, I would not be making this argument. The argument is being made under this statute because not only does the Massachusetts legislature, starting in 1992 and then amending it in 1994, see fit to make stalking a serious crime punishable by 5 years in state prison, but the Massachusetts legislature actually characterizes stalking in a way that directly dovetails and has an impact on our law of manslaughter, in that it deals with what would be essentially reasonable provocation, and in the nature of it, what a reasonable cooling-off period would be. The Massachusetts statute requires, as it's interpreted by this court, 3 events, more than 2 events. And it's the kind of event that's directed to a particular person. This is according to the statute.
Did the defendant, Mr. Jacobson, did the defendant ever go to the police to report the victim's threats or to take out a complaint against the victim or do anything like that?
The defendant never went to the authorities, Justice Cowan, but the defendant did tell 2 people who testified what was going on. 2 people testified
So
that they
he was
observed
very
this.
upset. He was emotionally upset by what was happening.
And not only that, Your Honor, but he had observed that the to-be ex-wife of the victim, Monica Hagan, had gone to the police, had gotten a restraining order, and nonetheless, the ultimate victim in this case came to the house and threatened.
So just because someone is being eaten up inside and upset about all this, so they should be able to go get a gun and kill the person, and that should be manslaughter? Is that what you're asking us to say?
No, I'm not. I'm asking you to allow the jury to consider what is traditional jury considerations for manslaughter.
Well, that means that we have to say that this could be manslaughter.
You would have to say that it could be, and I would like to address why I think you should say that it could be.
Folks who are very upset by what other people are doing can go get a gun and kill them, and that's only manslaughter.
What I'm saying here is that a person who is the victim of stalking, as stalking is defined by the legislature, that I'm asking this court to honor the finding of the legislature that says that that kind of behavior causes reasonable apprehension, that that kind of behavior causes substantial emotional stress, and that the threat may cause the person to be in imminent fear of death and bodily harm.
Right, and the legislature has provided what it sees as a remedy for people who are in that state.
Certainly, the legislature did not mean by that language to license people to go out and shoot other people.
This is not a self-defense claim, Your Honor.
I know it's not a self-defense claim.
I'm not, so therefore I'm not suggesting in the least that a person should be able to take the law into their own hands.
Well, do you think
Not
the
the argument.
legislature contemplated at all that people can go shoot other people and then say, well, it's manslaughter?
Your Honor, this...
I think what you're saying is the legislature has recognized in this statute that stalking creates a level of emotion in the stalked person such that it requires a large response, and you're suggesting, I think, your argument is that that level of emotion is such that in the circumstances of this case amounts to provocation.
What I'm suggesting, Your Honor, is this. The legislature is doing something interesting. It's saying you can't just look at events one at a time when you're talking about stalking, which you do in 99% of the manslaughter, voluntary manslaughter cases that come before the court. There's an event that occurs that the defendant is then responding to. In this situation, in a stalking situation, there are a series of events that take place over time and that involve threats to kill. And that when that occurs, that is so overwhelming that the events themselves cause this kind of emotional reaction, which is just the kind of emotional reaction that we anticipate. A person whose reason is being overwhelmed.
Did he testify?
Yes, Your Honor.
And he said this, what you're talking about?
Yes, Your Honor.
Okay.
Now, the basic concept of manslaughter that's not being questioned here at all is that the jury needs to be able to infer that a reasonable person in the defendant's circumstances would have become sufficiently provoked and would not have cooled off by the time of the homicide, and that, in fact, a defendant was provoked and did not cool off. I'm reading here from Commonwealth versus Zagrodny, a 2004 decision by this court. That's the fundamental concept here. I'm not disagreeing with that. On the contrary, I'm asking this court to apply the stalking statute to this idea. And all it requires is a recognition that the cooling off period, or the main thing that it requires, is that our normal concept of the cooling off period needs to be different when you're dealing with stalking cases. This is not a general exception. This is not saying a person, as Justice Cowen had asked me, a person gets upset, therefore they can get a gun. Not the point. The jury, in my opinion here, would have to find that the defendant himself was actually potentially a victim here of stalking. Not to say find in the sense of giving the defendant the burden of that. But the issue would be, is there a factual foundation here for thinking that this person was placed in imminent fear and that there was a series of acts occurring? The point about a series of acts is this. In stalking, and this is why when you read all the stalking, every state has a stalking statute starting in the 1990s. There's lots of written about it. The reason why it puts this person over the edge and in such a situation is that you don't know when the next act is coming. So something happens today, and these acts occurred over a 4-week period. Something happens today, a couple of days goes by, there's another thing that happens, the person approaches you, he comes to your house, he makes threatening phone calls. Various things are happening over time. So in this situation, it's recognized, that's why this court says there has to be 3 instances.
But so are you suggesting that the judge should instruct the jury that the legislature has decided that this kind of conduct is such that it can create in the person who's being stalked a level of emotion that the cooling off, that takes much longer to cool off? I mean, it's because the legislature has acted that you say this? Or because the legislature has recognized something that was already true?
No. I'm actually saying it's because the legislature has acted that I'm saying this. I'm not saying that the legislature hasn't recognized something that's not true. The legislature says to us that a person can be prosecuted without any expert testimony whatsoever about what caused that person to suffer emotional harm, the victim, what it is, whether or not he was actually placed in harm of fear, in imminent fear of death or bodily injury. All those things are assumed by the legislature that a lay jury can determine.
Isn't the test to instruct, I think you stated, from the case, Zagrodny, that to get the instruction, the jury, it would have to be found, or could be found on the facts, that a reasonable person would have had emotions leading to a killing. Reasonable.
A reasonable person would have to have emotions that overwhelm the person's normal ability to control themselves.
Yes.
In that sense. That's right, Your Honor. That's what I agree. That's what the instruction would be.
And could not the judge have reasoned that a reasonable person would not have reacted in this way, and therefore the instruction should not be given?
Well,
we're talking not a personal subjective feelings of the defendant, what a reasonable person would do. That a reasonable person would go to the police and do whatever needed to be done to get the stalker off, or the court,
Go to court.
after off of his or her trail.
some reasonable person would do that. I
Is there
suspect.
any state, all 50 states have these statutes, you said.
Yes.
Has any state that you found applied it to say one can get a manslaughter instruction?
No. On the other hand, these laws are 10 years old, or getting now 20 years old. I've looked. The facts don't come up very often where the victim actually then turns around and does, the victim of stalking actually turns around and does something. But the
Mr.
reasonable
Jacobs-
person statute is addressed, the reasonable person, if I may, Your Honor, is actually addressed in the stalking statute. That is, the stalking statute itself is cast in terms of, did this actually cause this harm to the individual, and was it reasonable to cause this harm? This very concept is embedded in the Massachusetts legislature, that they're saying to us, as citizens of this Commonwealth, including this court, accept that this happens.
It seems to me, Mr. Jacobson, that even if we were to agree with you, I mean, that it's an objective test, correct?
It is.
Right? No. Even if we were to agree with you that we should somehow take the stalking statute into account, it's an objective test, correct? And in this particular case, there were two stalking victims, correct? The estranged wife
Yes?
and your client.
Yes?
And what a reasonable person could do, and in fact did do in these very same circumstances, was to go and get a restraining order.
I suggest, Your Honor, they weren't the very same circumstances, and here's why. At the beginning of this period of time, the estranged wife went and got a restraining order. It was, in effect, violated by the person who turns out to be the victim
That is
of being
often
shot.
the case.
During the next period of time, that's no longer the same circumstance. Because now, from the point of view of my client, he's observed that having a restraining order does absolutely no good. Now, one of the things about the stalking
That
statute.
sounds like a self-help argument, not a heat of passion and no cooling
No.
off.
Here's the problem with stalking. It doesn't put you in a reasonable state of mind. It makes you very distressed. It makes you very upset. It tends to overwhelm your reasons. It drives people to drink.
Well, your argument taken to its logical conclusion would mean also that people who get restraining orders, if the restraining order is violated once or twice and they get a little bit upset about it, there's a natural reaction, can go out and kill the person who's the subject of the restraining order and say it was manslaughter, right?
Well, in some of those situations, it very well may be manslaughter, Your Honor. The question is, was it manslaughter in this case? You know, if I may say, one of the unusual things when I try to think about this manslaughter law that I'm aware of and other criminal law is the way this court and other courts set specific periods of time for the cooling off period. You don't leave it to the jury to decide the cooling off period. You say, well, 3 days, 2 days, 1 day, 2 hours. You set all these times. And I understand why that's necessary, because otherwise there needs to be some parameters here for the kinds of situations in which an individual can be allowed to escape the ultimate punishment of first-degree murder. So the jury is not allowed to consider all of these things by themselves. And I'm not suggesting that they should be. I'm suggesting in the case where a person appears to be the victim of stalking, and there's lots of evidence that he used those words, it turned out, not knowing the significance of them, to some people who testified about that he felt he was. He was twice threatened with being killed. The person who was the ultimate victim in this case of being killed came to this man's property. Where was he safe exactly? What would have a restraining order done? He could have left town. If a reasonable person, if it were me and I was really afraid, maybe I'd move to California and try to hide. But staying where I was and calling the police would not convince me, especially where this man had ignored a restraining order in the past, that was actually going to do very much for me.
Brendan, as I recall, and maybe I'm wrong and you can correct me, was a fairly expert shot, was he not?
I think he said he was a good shot.
Yes, he was a good shot. And the killing itself was such that he not only shot him once or twice, but to make sure he was dead, shot him again?
Yes, Your Honor. He was very angry at him. He was very angry. Now, that happens in manslaughter
In his house
cases.
had at least one long gun. Did it come out in evidence he had any other weapons at his house? He obviously, or wherever he had it, the gun that, the rifle, whatever it was, shotgun. What was it, a shotgun?
Yes.
Yeah, shotgun. That killed the victim. Did he have any other guns?
I don't know the answer to that question. whether he had other guns or not. According to Monica Hagan's affidavit,
Is there any evidence that the so-called stalker had weapons?
I believe there was. I believe he said he had heard that he had guns, and also that he was a karate expert of some kind of black belt expert, and that he was intimidating to other people. But all of these questions, Your Honor, I think are appropriate to try to determine whether or not, in this particular case, he was in fact reasonably provoked. What I'm saying is we need to recognize the effect of the statute on our concept of what reasonable provocation is when you get repeated acts of stalking. And we need to recognize that the cooling off period is inherently different with a stalking victim.
You know, Mr. Jacobson, I have to say that if the victim had come to the defendant, who knows, you might have had a different argument, but here, didn't he leave the trailer and go
To the victim's house.
to the victim's house?
Indeed,
In other
he does.
words, if you're saying, look, the restraining order isn't going to help me, but I'm going to be ready, you know, if somebody comes to me.
He was asked, I believe, during the trial, why it is he didn't immediately respond to the last threat to kill by doing something, which occurred maybe a day and a half or 2 days before. Why didn't you do something right then? He said he wasn't torn up by it so much. He wasn't at that moment so overwhelmed by it. That is, let me address 2 points here. One is, you're right, he went to the victim's house with a shotgun.
With the intention to shoot him.
It doesn't say that, Judge. It says he went there with the intention to scare. He says he went there.
What am I reading from here? Page 7 of your brief.
He's,
Is that the reply brief?
page 7.
No, the blue brief. Yeah.
Well, that's even worse for you if that's what he testified to, because that means...
I get out of the vehicle with my shotgun. Defense attorney, do you have an intention? Yes. What was your intention to shoot him?
We had a misunderstanding. I had a misunderstanding. I thought you said when he left the house, did
no,
he have
no,
an
no.
intention? No. When he left the house, this is what it says on page 7. When he left the house,
Yeah.
he had intention to go there and scare him. He had enough of this. When he saw him, he became overwhelmed with a passion about how much he hated living this life with being threatened all the time, and he shot him. And the fact that he shot him several times is just consistent with how horribly upset he was. Again, this is not an excuse in the sense of he's not guilty about something here. This is what's called an understanding of ordinary human frailty, which is the kind of thing manslaughter is meant to address.
Did you have it, was there an expert who testified as to his mental status?
No. And what I'm saying about there was none, and what I'm saying is since none is required in stalking statutes to prove this state of mind, that is, the stalking statute doesn't require an expert to prove this at all. The legislature is not requiring that. The legislature is saying to us, accept that these kinds of emotional states occur. We don't need an expert to say he was in some, we're not saying he was in some bizarre mental state. This is not a mental health defense.
Well, in a way it is. I mean, it's saying that he's overwhelmed. I mean, it's mental health in the sense that you're saying he was so overwhelmed by the actions of the victim that he...
affirmatively gets into
Right.
his car, drives, not
Right.
in evidence, but you say 22 minutes, and, you know, goes seeking out somebody to shoot.
No. Your Honor, I believe that's misstating the facts. He
Well,
goes seeking out someone to scare them. I don't mean to quibble about this, but I think it's significant.
But by the time he gets there, he changes his mind.
When he
He's
gets there, he
comfortable.
changes his mind.
But why?
Your client-
He hadn't seen the victim.
He does see him. He sees him outside.
I take it as I read the record, your client did get a diminished capacity instruction with respect to intent. Did he
Yes,
not?
Judge.
And that's not adequate, you say?
No. This is not a diminished capacity issue. This is an issue of whether or not he was reasonably provoked, given all the conduct against him, and whether or not reasonably he was still within a cooling off period. And what I submit is this. Had he gone away and was away for a month and came back and decided to go shoot Weymouth, it's clear that he would have not been within a cooling off period. But he was within the very periods of time that he was being threatened, that people were coming to his house, that the ultimate victim was coming to the house, that Weymouth was coming to the house. That is, it's within the period of time of him being stalked. I see my time is up.
Thank you, Mr. Jacobson.
Thank you.
Mr. Thompson?
Good morning, Your Honors. Robert Thompson on behalf of the Commonwealth. Your Honors, in referencing the stalking statute and the treatise, the articles and discussions submitted in the motion for a new trial about the possible effects of stalking, the most the defendant has shown is that stalking can cause a substantial degree of emotional distress. He claims that that by itself is enough for him to get a provocation instruction. Your Honor, that's not the law in the Commonwealth, nor should it be. In the Commonwealth, what is required for provocation is such sudden, overwhelming circumstances that eclipse a person's capacity for reflection or restraint, eclipse a person's capacity for self-control. There's no indication in anything presented by the defendant that it is recognized that stalking has that result on
Because
anybody.
most manslaughter instructions, almost all of them that I can remember, come under the sudden prong, where the two people are in the room or in the bar room or in the street together or someplace, face to face, and the passion occurs.
Yes, Your Honor, Your
Here,
Honor.
there's nothing sudden here. This guy
Nothing
all of a
sudden.
sudden decides, well, now I'm going to go over and scare this guy.
Nothing sudden here, either as a matter of subjective analysis or objective analysis, Your Honor. And I would agree with the court that,
It's
that
objective.
for voluntary manslaughter, the suddenness is the very essence of the provocation, because it's a matter of overwhelming a person's ability to control their conduct. Here, Your Honor, it's just a matter of, the only thing that's been shown is that there can be some degree of substantial emotional distress, not the overwhelming incapacity to control the conduct.
Mr. Thompson, do you think, I know it's not this case, and Mr. Jacobson, because the statute doesn't need to be, but do you think that if these facts, if an expert had testified that this person suffered from an overwhelming incapacity to control himself because of the stalking, and within these time periods, do you think that might warrant a manslaughter instruction?
Your Honor, that would, the way you described it, that would approach the subjective aspect of that, because it's for provocation law to be entitled to instruction. There must be a basis both that a reasonable person would have that reaction and the defendant did. That might go to whether a defendant did. To get to the objective side of it, you would need more than that. You would have to have a expert that said that
That anybody would have done that?
that a reasonable person who is a victim of stalking would no longer be able to control their conduct, Your Honor. And that is not here at all. That's getting closer to what has been presented and accepted in a battered women's syndrome.
Yeah, that's what I was thinking about.
But,
Right.
but it's just not here, Your Honor, and there's certainly nothing either presented by the defendant that would suggest that, yeah.
Right. I was just really trying to inquire whether there's a you think that provocation needs to have some temporal boundaries.
Well, Your Honor, I am saying that agreeing with Justice Graney, that is the essence of our traditional voluntary manslaughter law, and I suggest that is indeed good social policy, and I'll get to that in a minute. But I'm also saying that there's no indication here that there is any recognized lack of capacity to control behavior that's associated with stalking or being a victim of stalking.
In this case or generally?
In this case or generally. Your Honor, the way the law stands now, with provocation being a very limited, very confined theory of the law, is absolutely appropriate because it gives a strong, unequivocal statement to the public that there's a social duty to absolutely refrain from unlawfully killing anybody, no matter how reasonable you might be emotionally charged or how reasonably your desire to do so. If you can control that desire, you must do so. That's the lesson now, and that's the appropriate lesson now, Your Honor. There is no good social policy reason for suggesting that the law should become more tolerant of unlawful killings and just expand it to include any situation where somebody just has a strong emotional impact from the circumstances. I suggest, Your Honor, as a matter of principle, that would open the door hugely, and the vast majority of what is now considered murders would involve a question of voluntary manslaughter. Certainly in the domestic situation, most every divorce, every breakup, every child custody case, strong emotional reactions are the norm, not the exception, Your Honor. Your Honor, such expansions of the voluntary manslaughter law in this Commonwealth, which at least the model penal code might, for instance, suggest that would be an appropriate expansion. Any kind of strong emotional contact, Your Honor, I mean, it's outlined in my brief. That's essentially that they have a much broader concept of provocation.
I don't think even the model penal code goes this far.
Your Honor, it does suggest I believe that a understandable, strong emotional reaction to the circumstances can be enough by itself. It's not so confined.
We're not going to adopt the model penal.
Well, Your Honor, I was going to suggest the court has repeatedly rejected that, Your Honor, and
Pull up Professor Wexler. I think he would be turning in his grave if he thought that that's what this intended. I mean, there may be other reasons, but I don't think that's his. Well, they didn't even have stalking, so.
Your Honor, I'd also suggest that as a matter of subjective analysis here, there is no support for the idea that the defendant was, in fact, overwhelmed by the circumstances, that he couldn't exercise any degree of control. In fact, his own descriptions of his deliberate preparations in this case, of how he went and loaded up his shotgun with buckshot, knowing that it was going to be a lethal load to kill anybody, stating, despite what my brother says on cross-examination, that he was recognized that his intent was to be prepared to kill the victim in this case when he's loading the shotgun. He goes to there. He does say that he thought that he would probably just scare the man, and that if the victim was in his house and therefore could see him coming and therefore possibly arm himself, then he wasn't going to go forward. But instead, when he found the victim standing in the front yard, unarmed, barefoot, well, then this is his opportunity, and so he goes forward. This is not the description of a man whose capacity for control and restraint is overwhelmed. This is, in the language of Commonwealth versus Benson, which is at 432 Mass 180, this shows the calculus of survival. He decided to eliminate what he saw as a threat in his life. This is simply not the actions of someone, again, in the language of Benson, acting out of the blindness of the heat of passion.
Johnson, was the, I may have this confused, but was it on the day that this happened that he and Ms. Hagan, the evidence was, drank 3 bottles of champagne?
Yes, it is, Your Honor.
Okay.
He had testified that goes to some degree
Okay,
to the cooling off
what I wanted
period.
to ask you was this. The, Justice Cordy asked about the diminished capacity, right, thank you. Was the instruction on that based on the alcohol and drug consumption, or was it this mental condition, or both?
Your Honor, the basis for the instruction, I think, was generally recognized as the intoxication. Right now, I don't recall whether the instruction itself was limited in any way to intoxication.
Or whether it referenced the, did it reference the mental health issues?
Anything else.
Yeah, I just didn't, yeah, okay.
On the cooling off period, Your Honor, this is a situation where the defendant's own testimony here, again, he describes that after the last potentially provocative incident, which is several days earlier, where there was a confrontation at a gas station where the defendant says that the victim said that he was going to kill him. he said that he didn't immediately react to that. He didn't immediately go out and take care of any action on that because it didn't really affect him that much at that time. And it was only after he mulled it over, considered it longer, built it up, fed apparently his anxiety with large consumption of alcohol, cocaine, and Percocets, and now he decides to go and do this thing in what I've suggested is a very deliberate fashion. Again, this is just the opposite of cooling off. I mean, he's in fact testified that he was in fact cooled off before he went and back and decided to go forward and eliminate this, what he perceived as a threat in his life. Your Honors, I suggest that any such expansion as requested by the defendant in voluntary manslaughter is entirely unwarranted, and I would, if there's no further questions, simply ask you to affirm the conviction.
Thank you, Mr. Thompson.